Using a website terms and conditions, what you need to know. Your website terms and conditions is a contract between you and your customers. When a visitor to your website agrees to your terms and conditions, a legal contract has been created between you and them. If the visitor has signed the terms and conditions by clicking I agree, the courts consider the terms and conditions enforceable. Virtually every state has adopted one type or another terms and conditions language, accepting the idea that when a visitor accepts the terms and conditions, it is a binding contract even if no one agrees to it in the traditional contract law sense. Every court to consider the issue has found terms and conditions in which an online user clicks I agree or some other similar language enforceable. What if there is a terms and conditions but without an I agree button or acknowledgement? Many websites that have a terms and conditions do not require the visitor to click on I agree before using the site or making a purchase. This is not the ideal way to protect yourself when doing business online. The courts are considerably less likely to enforce your terms and conditions without having a user click on or check some type of I agree. If you do have a click to agree button, make sure the customer or user sees it. In the court case Specht versus Netscape, the court said that when users were invited to download the free software, the website did not have a plainly visible notice of the terms and conditions. Instead, visitors would have to scroll down the page below where the download button was and click on a link to view these terms and conditions. The court explained the contractual nature of website terms and conditions was not apparent to all users and determined that a submerged link below the fold of the page was not adequate to make the consumer aware of the terms. The court further stated that a reasonably prudent Internet user in circumstances such as these would not have known or learned of the existence of the terms and conditions before responding to Netscape's invite to download the free software. Although there are cases where the courts upheld a website's terms and conditions when the user did not have to click I agree, it would be unwise to count on it. In the case of your terms and conditions, it will probably never get enforced without the visitor specifically clicking on I agree to accept your terms. While the previous information may make a business owner feel safe just because they use a terms and conditions, it's also vital that it is professionally drafted to contain the correct wording. In fact, many courts have enforced a terms and conditions agreement against the business owner, thus using it against them instead of for them. A business owner who uses the correct language can help protect themselves from these situations and most reasonably foreseeable events. To get your website terms and conditions statement, visit www.disclaimertemplate.com/0075.